Hi, I'm Antonio Mora. In the latest episode of DC politicians behaving like petulant kids who throw a tantrum if they can't have their way, 5 Democratic senators attacked the integrity of the Supreme Court. They did it as part of a brief filed with the court in a gun control case. They decided to use the brief as a political tool, in effect, accusing the conservative justices of being partisan hacks whose decisions are, quote, motivated mainly by politics. Worse yet, the brief issues a not-so-veiled threat, saying the court needs to heal itself, because if not, the public will demand it be restructured in order to reduce the influence of politics. I'm no Pollyanna. Nobody is immune to bias, including the justices, and I have no doubt politics has influenced both conservative and liberal justices. But this is where the brief really flies off the tracks. It argues that the conservative justices vote in lockstep in a large number of cases, and that in almost all cases decided by a 5-4 or 5-3 vote, the decisions favored Republican causes. Of course, the Democratic senators conveniently ignore the fact that the liberal justices are just as consistently voting along partisan lines favored by Democrats. So it's okay for them to vote in lockstep, but not the conservatives. It's a case of what's good for the goose not being good for the gander. These days, asking our politicians to be intellectually consistent is like asking for a tiger to change his stripes. They also don't mention the many cases where conservatives vote with the liberals and vice versa. Plus, they make a major sin of omission, leaving out the fact that, according to an article in the Washington Post, the justices agree far more often than they disagree. Since 2000, unanimous decisions are the most likely result in 36% of all cases. Many of the other rulings are 7-2 or 8-1, with liberals joining conservatives and vice versa. In fact, 5-4, 5-3, and 4-4 decisions only happened in less than 35% of the cases. In the 2016-2017 term, 56% of all decisions were unanimous. In the past session, according to my calculations, more than 80% of the cases were decided by 6-3 or larger majorities. That said, it's fair to be concerned, because the tight decisions are often in the most significant cases, the ones where the court really exercises its power in ways that change American society and the way we live. The founders, though, may not have wanted the Supreme Court to be as influential as it now is. The Constitution simply states that the judicial power of the United States shall be vested in one Supreme Court. Alexander Hamilton wrote that the judiciary will always be the least dangerous branch to the political rights of the Constitution, believing it would be above the political fray. Instead, as political polarization has worsened in Washington, leading to congressional gridlock, the court's outsized influence has kept growing. So has the polarization around the court itself.
I've heard that a president's most important decision is who he or she picks for the United States Supreme Court.
Nominations for the court have triggered some of our most heated political debates. The confirmation of qualified justices has gone from a bipartisan sure thing to all-out political warfare. 25 years ago, Ruth Bader Ginsburg was confirmed with a 96-3 vote. Compare that to Brett Kavanaugh's bare minimum 50-48, or Neil Gorsuch's 54-45. Even worse was when Republicans didn't even allow nomination hearings for Obama nominee Merrick Garland. In light of the polarization, Democratic presidential candidates have various proposals to reform the court, including an increase in the number of justices. FDR failed when he tried to do that in 1937 in order to obtain favorable rulings on New Deal legislation. Since then, court packing has mostly been seen as a fringe idea. It probably still is, unless Democrats win the White House and a large majority in the Senate. But it doesn't need a constitutional amendment, because the Constitution doesn't specify the number of justices. In fact, the number was only set at 9 by the Judiciary Act of 1869. The proposal may just be pandering to the base, something Democrats do in an election season as much as President Trump does. And a new Pew Research survey does show an unusually large partisan gap in how the court is viewed. Favorability among Democrats is at its lowest in 2 decades, with only 49% of them and Democratic-leaning independents having a favorable opinion of the court, while 75% of Republicans and those who lean toward the GOP view the court favorably. Most politicians would kill for that kind of approval rating, which is far better than for Congress or the president. But beware of making decisions based on fickle public opinion. In 2015, only 33% of Republicans approved of the court, and 62% of Democrats approved as recently as January of this year. How things change. Democrats may also want to learn from recent history. Harry Reid exercised the nuclear option to change the rules of the Senate to eliminate the need for Senate supermajorities and approve Obama-era nominees. That came back to haunt them when the GOP retook control of the Senate, and the rule change allowed Trump cabinet members to sail through over Democratic objections. And then the GOP extended the nuclear option to include Supreme Court nominees, allowing for the Gorsuch and Kavanaugh confirmations. Sometimes institutions need change. Maybe it is the Supreme Court's time. But threatening the justices and changing 150 years of tradition that have mostly served this country well don't seem like great ideas, and they would likely make polarization even worse.